Hello, everybody.
Court is on the record and calls first the matter of Katrina Thompson versus David Glenn Thompson. This is file 2017-16811 Welcome from front of the court, Ms. Spillane and sir, listed as David Thompson. Are you David Glenn Thompson?
That is the person that I was given to use in this life. And that proper style is upper lower case in accordance with SPR 89363, which is a court order to full faith and credit.
I'm going to speak one more time and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called the case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question, or the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes, I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate that.
Are you David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the front of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the front of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I'd prefer it go back to them.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based on my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter was, is, or should be aware of the fact that when posted, it couldn't be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you know, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court, but hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent, registered mail to Clerk DeVider, I think it is, and why that wasn't credited to the account, since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract or other words that, although they seem quasi-legal, don't bear any particular relation to this case. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Boyd, on this case?
No, sir.
All right, thank you. The court is at recess on this matter then.
Be safe, be well, sleep sweet, and much love.